Welcome to Lesson 3.2, all about the criminal justice process and investigations. In today's lesson, there's lots of little standards and specific Supreme Court cases that you need to be familiar with about generally the ideas of probable cause and reasonable suspicion. And we'll break those down into when the police can search you, seize you, and take away some of your personal freedoms. Here's your overview with your 5 main topics. Remember to take good notes. Now, the overriding thing to keep in mind is something called due process, and this is the idea that you're entitled to fair treatment in the legal system. It's sometimes known as procedural due process because it means that the state has to follow certain procedures in order to take away those personal freedoms that you have. It's guaranteed in both the 5th and the 14th Amendments to the United States Constitution. For more information about this concept, go ahead and click this link and watch through Due Process of Law. Keep in mind you don't need to take notes on that video, but it does provide you with a little bit more information if you're interested in it. So the first topic that we're going to take a look at is known as due process, and there are 2 standards to determine whether due process has been followed. The first is the idea of the probable cause standard, and this is the idea that specific information has led a reasonable person to believe a person committed a crime. This is required for a warrant and an arrest. So this is kind of the higher standard that's required for the police to search and to seize you. In order for someone to be searched, the 4th Amendment to the U.S. Constitution specifies that warrants would be issued with this idea of this standard. There is a lesser standard that's known as reasonable suspicion. This is the idea that there is a general circumstance, a whole bunch of different articulable facts, but it's a general set of them that lead police to expect that someone has knowledge of a crime. It doesn't mean that you necessarily did it, but you might just be in the vicinity of it. Generally, we would say that this is a lower standard and it allows the police to stop you and to frisk you for their own protection. It's allowed to detain you and to pat you down for weapons. They can't, though, for example, search you for drugs in that process. So this is sometimes known as a stop and frisk. It was first allowed by the Supreme Court case called Terry versus Ohio, so it's sometimes known as a Terry stop. An extension of this idea is that administrators at schools only need a reasonable suspicion in order to search someone at a school, a student at a school, that is to say. So for example, if the school principal wanted to search your locker, all they would need was reasonable suspicion that you have knowledge of some sort of crime. So it's a lower standard and you have a lesser expectation of privacy of your belongings and of your stuff at school. Now generally when we look at those 2 standards, we talk about 2 things. We can talk about seizures, which is when the police take your person, or searches when they look through your property. So there are 2 levels of seizures. There's an investigative detention and there's an arrest. And you can see there that arrests are when you are essentially not free to go. You are transported without consent to another location, and you lose your ability to protect your privacy. So they can search you without consent if you have been arrested. That requires probable cause, and you have to be informed that you're being arrested. They don't have to inform you why you're being arrested. That's a common misconception. The lesser level is the investigative detention. That's that Terry stop idea that was on the previous slide. Now, carrying those 2 standards forward into searches, let's talk about searches with a warrant and then warrant exceptions. So we already established that with reasonable suspicion, they can pat you down only for their own protection to determine if you have a weapon. So they'll say, do you have anything on you that could hurt me? And they'll pat you down, but they can't search you for anything else in a stop, in a Terry stop, that is to say. Anything beyond that requires a warrant. Police have to get a warrant from a judge to search property or a person, and they have to have probable cause for that. If they search you without a warrant, there's an exclusionary rule that means any evidence they find is not admissible in court. So it's not a good idea to try to stop the police from searching you, but instead later to hire a lawyer who would be able to argue that they did that search improperly. Now there are some exceptions that are listed there to the warrant. So for example, they can search a whole bunch of different ways without having to get a warrant. Most of the time these are exigent circumstances. So for example, if they're walking down the street and they hear somebody going, help me, help me, help me, inside a house, and they believe that someone is being harmed, they can break down that door and try to help somebody before getting a warrant. So there's a list of those exceptions there. Probably the most common reason that people don't end up having to get a warrant, the police don't, is because people consent to searches. Another one is that if you have a plain view of something, then they don't have to get a warrant. So for example, if they're walking up next to your car and they see that in the back seat you have 50 kilos of cocaine, that's in plain view. Another is lawful arrest. So if they've arrested you, they can go ahead and search you without getting a warrant as long as the arrest was lawful. They can also do stop and frisks, we've talked about that, and automobiles, they don't have to get a warrant for, but they still have to be able to prove later in court that they would have had probable cause. It's basically a way to get around having to call a judge every time they want to search a car. The final concept that we'll talk about with due process and investigations before we get into the trials is the idea of use of force. The Supreme Court has established standards for how much force police and the state can use against you. And basically they have to consider the severity of the crime that is in question. So did you rob a bank or were you merely jaywalking? Whether you would pose an immediate threat to safety of other people and whether you're actively resisting arrest. And basically the Supreme Court has said that police can kill you. They can use deadly force if you pose a threat to the safety of others, even if you're running away. So a lot of times we've heard in the news about people running away and they get shot by police. It's important to know that that in and of itself doesn't mean that the police have committed a constitutional violation. What it means is that the police would have to show that they reasonably believed that that person was a threat to the safety of others. So for example, if a person with a gun is running away from police and shooting at the police and they're running away and they start running into somebody's house, the police can shoot that person. So there is a use of force continuum. I encourage you guys to ask our police officer when he comes to class about some of these issues. So hopefully you've taken good notes on this issue related to the criminal justice process and investigations, and we'll see you next time.